Good morning, guys. Welcome to Mug Briefing. One of Wall Street's most powerful legal executives is stepping down after newly released government records revived scrutiny over past ties to Jeffrey Epstein. In simple words, Goldman Sachs' top lawyer is leaving her job after documents from the U.S. Justice Department showed she had personal contact with Epstein years after his 2008 conviction. The bank says the resignation is meant to limit distraction. The timing matters because it pulls one of the world's biggest financial institutions back into the long shadow of the Epstein scandal, a case that continues to surface new names and raise questions about accountability. Here is what actually happened. In early February 2026, the U.S. Department of Justice released a batch of documents tied to long-running Epstein-related matters. Those materials included emails and records showing that Goldman Sachs' chief legal officer and general counsel, Kathy Ruemmler, accepted gifts from Epstein and provided him with advice about how to handle media coverage related to allegations of sexual abuse. The communications took place after Epstein's 2008 conviction. After media organizations reviewed the documents, reporting intensified between February 12 and February 13, 2026. Goldman Sachs CEO David Solomon informed employees and investors that Ruemmler would step down. The resignation takes effect June 30, 2026. The bank has not said she was fired. Public statements frame the move as a decision connected to reputational risk and distraction, rather than a legal judgment. The delayed departure suggests Goldman wants an orderly transition instead of an abrupt leadership gap in its legal department. The documents themselves are authenticated government releases. News outlets are quoting and summarizing their contents, not inventing them, but the public is seeing excerpts and reporting rather than a courtroom verdict. The records show association and advice. They do not, by themselves, establish that she broke any law. There is no public charge against her. The value of the gifts is not fully itemized in reporting. The advice described centers on media strategy, how Epstein should respond publicly, not on facilitating crimes. That distinction matters legally, even if it does not erase reputational concerns. Why is this happening now, years after Epstein's death? The answer appears to be document timing. Epstein-related files have been released in phases as legal battles over disclosure continue. Some records were sealed or not widely public until recently. Each release can surface new names and reignite scrutiny. This is less about a brand new incident and more about newly visible historical information entering the public record in 2026. What this likely means is that Goldman is prioritizing reputational containment. Supporters of the resignation argue the bank acted quickly to separate itself from controversy. Critics may say the episode shows how elite networks remained intertwined with Epstein after his conviction. The core issue is not whether Goldman as an institution is accused of Epstein-related crimes, it is not, but whether a senior executive's past conduct undermines trust in the firm's governance culture. For Americans, the effects are indirect, but meaningful in terms of trust and oversight. Goldman Sachs is deeply connected to pension funds, public markets, and corporate finance. Clients want assurance that the bank's leadership reflects strong compliance standards. Investors watch for governance risk because reputational damage can translate into financial pressure if clients lose confidence. Employees inside the firm may feel short-term uncertainty about leadership continuity, especially in a legal department that oversees regulatory compliance. What happens next is likely to follow a predictable corporate path. Goldman will implement a succession plan and either elevate an internal lawyer or conduct an external search before June 30th. The board and compliance teams will review the episode and tighten messaging to clients. Regulators could review the disclosures, but there is no announced investigation at this moment. Civil lawsuits are possible in theory whenever high-profile documents surface, but none are confirmed as a direct result of this resignation. More document releases could name additional figures, which is why media attention is unlikely to fade quickly. It is important to say what this does not mean. Goldman Sachs is not being charged with Epstein-related crimes. The bank is not being fined. A resignation is not a legal admission of guilt. No financial penalty automatically follows from stepping down. The story is about reputational governance, not a criminal ruling against the institution. The situation would become more serious if regulators filed formal actions tied to the disclosures, or if lawsuits connected the bank to broader misconduct. Leadership instability would grow if additional executives were implicated. Financial consequences would only follow if clients began pulling business or if legal exposure expanded beyond personal association. The signals to watch are clear: whether regulators announce reviews, whether Goldman changes compliance or governance policies, whether additional Justice Department materials enter the public domain, whether the bank accelerates the leadership transition, and whether major clients publicly comment on their relationship with the firm. Stepping back, this is a story about how past relationships can resurface years later and collide with modern expectations of corporate accountability. A top legal executive at Goldman Sachs is leaving after government documents showed post-conviction contact with Jeffrey Epstein. There is no criminal charge in this announcement, but there is reputational fallout. The bank is choosing stability and distance from controversy while preparing for leadership change. For viewers, the significance is less about one resignation and more about how institutions respond when old associations reappear in the public record.